Hi, my name is Tom Blake. I'm a certified residential specialist with REMAX Liberty, and I'm fortunate enough to be sitting here with
Attorney Craig Reynolds.
Attorney Craig Reynolds of Reynolds Law here in Lancaster, Massachusetts, and he serves Worcester County. And
Middlesex County.
And Middlesex County, okay, and Middlesex County. So most of eastern Massachusetts then,
Correct,
I imagine,
yeah.
right? The purpose of our video today is I get asked all the time, do I need an attorney? Why do I need an attorney? As particularly with sellers, they're like, do I really have to pay for an attorney? So I wanted to sit down with Mr. Attorney Reynolds here and get his perspective on how he protects his clients. And so let's start off with so this is an attorney state. So we were talking about this before the video. Right. Can you define what an attorney state is?
Sure. So across the country, real estate practices differ dramatically from state to state. Mm-hmm. What the rules, what the regulations are, what the customs are. Massachusetts is known as an attorney state in that any real estate closing, you have to have an attorney handling the closing here in Massachusetts to do the title work and handle all the paperwork for the closing. In much of the country, you have title and escrow companies.
What's the difference?
The significant difference there is in the rest of the country where you've got title and escrow companies, you've got third-party vendors. They don't represent anyone in the transaction. They are simply providing a function, a paperwork function. They're doing the title search. They're handling the paperwork and whatnot. But they don't represent anyone. They don't have any responsibility to anyone other than just to do their job well. Whereas in Massachusetts, the attorney that's handling the closing is representing, has an actual relationship with and an obligation to the parties that they're representing. So the buyer, the lender. So in any given transaction, you're going to have three parties. You're going to have the buyer, you're going to have the seller, you're going to have the lender.
Right. Yep.
And in most instances, all three parties are going to be represented by an attorney, just the way we do things here in Massachusetts. But for today's purpose, talking about the buyer side. So the buyer's attorney has an obligation to the buyer to represent them to the best of their ability. Proactively looking for issues, protecting them against issues to make sure that they get the desired result at the end of the day.
Okay. So we're talking when you are hired. Well, are you hired by the buyer or are you hired by the bank or?
No, really good question. So in most instances, the vast majority of instances where I'm representing a buyer.
Okay.
If they're getting financing, I'm also representing the lender in the transaction.
So at the same time?
At the same time. So the initial reaction is often, well, you can't do that. You can't represent two parties as a conflict of interest.
Okay.
But the thought is it's a team. The buyer, the lender on the team, they're after the same objective. It's very rare that there's something that the buyer wants out of a transaction that differs from the lender and vice versa. So the norm is to have the same attorney serving in both roles there, and there's a lot of efficiencies. You don't have two attorneys stumbling over each other.
Yeah, that would be
looking at the same things, and through efficiencies, there's a lot of cost savings.
Okay. So where it's so I'm a real estate agent. So I typically, if I was representing a buyer, I would write the offer. The offer is then succeeded, would that be the right word?
Mm-hmm.
Yeah, by a purchase and sale. Now, who typically drafts the purchase and sale?
Yep. So just stepping back for a second. So somewhat unique to Massachusetts is the contract between the buyer and the seller is a two-step process.
Oh, okay, sorry.
So no. So well, you already alluded to. So you've got the offer contract, which is usually drafted by and negotiated by the agents.
Okay.
Starting with the buyer's agent's going to fill out the form, present the offer to the sellers,
Yep.
and there's some back and forth to get that in final form.
Okay.
That offer, what we refer to as the offer contract, is then replaced by a more formal contract, the purchase and sale agreement.
Okay.
Which is usually where the attorneys come into the game.
100%, because we're not attorneys, so know what you don't know. I'm not an attorney.
and the whole concept really goes back as long as I've been doing this. Goes back long before my day in the business, where the thought is that, and Massachusetts is really strict on only attorneys should be practicing law. It has been thought for some time and defined as such that negotiating and drafting language, that's an attorney's job to do that. So that way back in the day, kind of the truce between the realtors and the attorneys was that the realtors negotiate the financial terms of the deal, put that together in a relatively bare bones contract, again, the offer contract, that is then brought to the attorneys, and the attorneys do a much more formal contract, the purchase and sales agreement. That takes all those details and kind of fleshes it out, if you will. Now, those practices have evolved over the years.
Yeah.
There's not quite that strict line between what is and isn't the practice of law. So you have a lot of realty offices that will draft the purchase and sales agreement, using standard forms and such. And most realtors, even when they draft a purchase and sales agreement, aren't going to go so far as to start creating their own documents because they don't want that liability. But so the liability falls on us as the attorneys. So that's why we have a two-step process. And even though the roles have blurred a little bit, it's not quite as strict. Don't cross this line as an agent. And it's still the process to have the contract is a two-step process. Back to your original question, the purchase and sales agreement, the real contract, is typically always drafted by someone on the seller side. Sometimes the seller's agent, the listing agent, more and more often these days, the seller's attorney.
Sure.
So in all the years I've been doing this, practices have evolved there as well. So in this immediate market area here, the greater Leominster, Fitchburg market, if you will, it used to be really common for many buyers and sellers to get through a deal unrepresented because the realtors would step up and kind of play that role. They would draft the documents, they would explain the documents, and then the realtors started realizing that's just not our skill set. And that's why are we taking on this liability? Sadly, my pathetic skill set is words.
It's far from pathetic. You actually understand a completely. Let's stop you for a second, okay? You understand like a completely different language. And when I'm reading through the purchase and sale, I understand that I don't understand. Like when I first became a realtor, I understood that I was just smart enough to get sued.
Sure.
So you really have he has an amazing grasp on a language that most people don't understand and really confuses people. So if we go back to the purchase and sale, so I would draft an offer, right, instructed by my buyer, and then you would get the purchase and sale from the seller's attorney once everybody's agreed on that. And what would you do for the buyer as you were reviewing? Like, what are the parts of the purchase and sale that you would review through, and hotspots that you would be looking for?
Sure. So just as I explained to many of my buyers, when we get into this process, just first kind of explaining why we have this. Why they have to deal with me, why they have to bring an attorney in here, why we have this two-step process and whatnot. But so the purchase and sales agreement, the final contract, as I described, it's the rules of the game. It's going to describe exactly what the details of the transaction are, and it's going to cover all sorts of scenarios. What happens? What is expected of the seller? What is expected of the buyer? What happens if something goes wrong along the way? What happens if one of the parties can't do what the contract calls for? What happens if someone just chooses not to do? What are the ramifications for that? So we're fortunate. The vast majority of transactions we're all involved in here are very smooth, very friendly, and literally you could have done it on a handshake. But that's not always the case. Sometimes there are surprises that come along, new information that comes along that either party is like, whoa, had I known that, I might be approaching this transaction differently.
Right.
As a buyer, maybe I don't even want to be buying this house if I had known that. So my job is to basically, when I'm representing the buyer, protect them against all the what ifs, protect them against surprises, protect them against the seller turning out to be just the biggest jerk ever, and they're going to try to pull a fast one. My job is to make sure my buyers get the transaction that they signed up for, and also if we come across information along the way that would reasonably lead them to have said, I wouldn't have even made an offer on this property if I had known X, Y, or Z, to anticipate that and protect them against that. So in general terms, just making sure they get the deal that they think they signed up for.
Yes. And so Craig just said an enormous amount in a short period of time, and it's typically like an 8 or 9 page document a lot of times.
So so what we pride ourselves on, and not all attorneys do this. I'm sure some do, but I'm always surprised how often it seems to be the attorneys on the other side of the transaction
Okay.
really aren't going into that much detail with their clients about what the contract is.
Yeah.
So I mean, just one thing where we distinguish ourselves from, what we pride ourselves on, where we try to distinguish ourselves from the pack, if you will, is just a level of education we bring to a transaction. So there's never a case where I'm just going to give a document to someone and say, I've looked at it, it looks good, sign it. That just doesn't fly. So it's all, whether we're talking about the purchase and sales agreement or through to the closing process, every document that's being presented is critical to us that our clients understand what they're signing. So specifically on the purchase and sales agreement, when we get that draft from the seller's attorney, we're going to send that to the buyer. We're going to set up an appointment, whether it's phone or Zoom or whatever.
Right.
More and more Zoom. That's kind of fun.
Zoom is easier.
And go through not word for word, but all the critical provisions in the purchase and sales agreement to make sure they have a clear understanding of what the contract requires of them.
Sure.
Point out to them some of the things that can go wrong with the transaction and some of the language that we're then going to add into the purchase and sales agreement.
Okay.
We're always adding language to the purchase and sales agreement drafted by the sales attorney to protect our buyers. Give them some background on why we're doing some of the things we're doing, so that they're alert to the sorts of issues that could arise. So that we kind of work together as a team to make sure that we're spotting those issues and can address them properly.
Yeah, the best surprise in real estate is no surprises.
Exactly
right?
so. Exactly so.
Just for fun, can you think of a particular incident where the seller wasn't playing nice and you needed, like, obviously, scratching out all the names to protect the innocent or whatever.
Yeah.
But is there do you have a story in mind that maybe you could share that sticks out where you really?
So just the most egregious. It's just where we have sellers who have changed their mind along the way, and they're just at some point say,
What do you mean change your mind? Like they don't want to sell anymore?
Don't want to sell.
Really? Okay, so this never happened to me before. So you've actually, what do you do? What?
Yeah, so it depends on the circumstances. So we've had sellers try to pull out of a deal because they were selling because they had some life event that led them to selling, like job transfer, something like that.
Oh, okay.
Then the job fell through.
All right. Or
things like that.
Somebody gets cancer. Who knows? Something horrible like that.
Exactly so. So depending on the situation, basically it's very. If we've done our job properly as the buyer's attorney, we have a really tight contract. There's nothing in that contract that's going to give the seller the inappropriate opportunity to try to wiggle out of the deal. So the contract's binding. The buyer's entitled to enforce that contract.
Yeah.
So if you have a seller who's trying to pull out of the deal, we just make it clear to them that's just not a viable option. You signed a contract. We're going to make you sell this property. And one of the remedies. So going back to the concept of anticipating someone not doing what they're supposed to, what are the ramifications? So the ramification there is the buyers within their rights under our legal system to enforce the contract to what's called specific performance. We're going to make you sell the property.
Wow. Have you ever had to do that?
We have.
Oh boy, that must have been
exactly so. That's kind of worst case.
That would be worst case scenario. Are there any what's so?
The most common, so when we're going through a purchase and sales agreement with our buyers, one of the most important parts of that is making sure we're understanding the property. When you buy a house, what you're actually buying is a piece of land that happens to have a house sitting on it.
Right.
But you're buying a quarter acre with a house, or you're buying 10 acres with a house. And in some cases, the property itself has restrictions on its use. There are easements through the property, an easement being someone else has the right to be on the property to do something, a shared driveway, a drainage pipe through the property, things of that sort.
Is that a title search or is that something
That's something we find through the title search.
Oh, okay.
Exactly so. So I've had any number of transactions where just at the purchase and sales agreement stage, we're reviewing the property with them and saying, so if we can find maps and whatnot, we say, here's what it looks like. Here's your 2 acres, quarter acre, whatever the case might be. By the way, the deed makes reference to, or the survey that's on record makes reference to, there's an easement through the property, or there's a restriction on the property. Were you aware of that?
Okay.
And in some cases, they weren't aware of that, and what we're showing them is going to be problematic for them and how they're wanting to use the property.
Like maybe the driveway goes over somebody else's land or something like that.
Sure,
or maybe
that's something we need to be concerned about.
Sure.
So we've an example I often give I teach a lot of continuing ed classes.
Yes, he does.
So one of the examples I just always fall back on is a situation where we had a client some years ago that was buying a single family house, had no garage, and they had done their homework. There was plenty of space on the property to add a garage.
Okay.
It was critical to them that they have a garage.
Okay.
They didn't want to live life if they didn't have a garage.
Okay.
What they didn't know, and what no one knew at the time of the purchase and sales agreement, or when they made their offer on the property, is that there was a drainage easement on the property. There was the drainage pipe running through the property, right where the garage was going to go.
So they couldn't break ground. It wouldn't.
So, underground pipe there for the
Okay.
benefit of the neighbor. You can't put a garage over the top of that.
Oh boy.
So the buyer was like, "Well, I can't buy this property. I want out of the deal." Unbeknownst to them. Now I say they were clients. They actually weren't, because I would be at fault here if they were my client and they got and they ran into this. I was just the lender's attorney at this point. This particular buyer didn't have an attorney representing them, so no one had counseled him on any of this.
Oh my goodness.
So the standard language in the purchase and sales agreement that basically alerts buyers that maybe when you do the title search, you might find easements, you might find restrictions.
Right.
And as long as whatever you find isn't problematic for how the seller is using the property, you agree as a buyer to take title subject to whatever that might be.
Sure.
So that language is necessary in the contract, because invariably you find some easements, restrictions, and they're just not problematic. They're just normal sorts of things you find. A utility pole, a telephone pole. There's an easement for that.
Sure.
So we need that language in every contract that the buyers won't object to just normal easements. But the critical language is you won't object to any easements that don't interfere with the current use of the property. The assumption being that the buyer is going to intend to use the property in the same fashion as the seller.
The current use of the property. So this is why words really matter. This is the language that you understand, that somebody like me or the average person just would miss.
It wouldn't jump out you as being critical.
No, not at all.
So in that particular case, the drainage easement wasn't problematic at all for the seller.
Right.
It was problematic for the intended use of the buyer.
So another thing that you do is you protect the person's deposits. So how in that particular instance you represented the bank.
So
was that person's deposit at risk because
they walked away, they lost their deposit. Yes.
Wow.
And back then, this was some years ago. So it was a relatively small deposit. It was $5,000, but still
that still would stink.
$5,000
is $5,000.
Exactly so. So I learned at that poor person's expense. So thousands of transactions later, thousands of purchase and sales agreements later, I have asked every single one of my potential buyers, what are you going to do with the property? And do you have any plans? Are you going to add a room to the house? Are you going to put up a secondary structure? Are you going to put a swimming pool in the backyard, sort of thing? And invariably, most people have plans of that sort.
Okay.
So the follow-up question then is extremely unlikely. But if we were to find some sort of restriction, some sort of an easement, some reason that you can't do that, would you still buy the house? Most buyers are like, we'd be disappointed, but we'd still buy the house. But some buyers are like, I won't buy the house, this property, if I can't do that. In which case, we need to modify the language in the contract. We need to change the language in the contract to protect them against that possibility, so that if we do a title search, if we find a restriction of that sort, their deposit is protected. They can walk away from the deal.
Okay. So, as a buyer, you're putting an awful lot of. You found the house, you've been looking all over the place, you finally found this house, you think it's the best thing since sliced bread, and you're putting down an awful lot of your hard-earned money and you're committing to it the second you put your name on that piece of paper. And so Craig's job is clearly to make 1,000% sure that that money's safe.
Exactly.
Right?
So basically, over the years, every time we have a transaction that didn't go as smoothly as it should, where an issue of some sort arose and the buyer kind of got the short end of the stick, if you will.
Yeah.
That leads to an evaluation of how can we better protect future buyers against that exact situation.
Yeah.
So the list of things that we incorporate into our contract to protect our buyers against scenarios, that list has grown and grown and grown and grown.
Okay.
Another example, we had a situation where we were working with buyers, and we had done our due diligence. We'd pulled up the seller's deed. We understand what the property looked like. We showed them the assessor's map and say, okay, here's this quarter-acre lot that you're buying. And they're like, no, we're buying a half acre.
Okay.
So long story short, it turned out that there was the property consisted of a house lot and an adjacent vacant quarter acre, which was the side yard, which is what attracted them to the property.
Okay.
Really long story, very short. prior transaction, all the players in that transaction had not paid attention to the details. And when the seller, the people that are now selling the property to us, when they bought the property, they only bought a quarter acre.
Okay.
They didn't buy the half acre, and they didn't even buy the quarter acre that had the house on it. They bought the quarter acre that was vacant. Right?
Oh no!
So they've been living in the house all these years, using both the lots, assuming that they own both the lots, but they didn't. They only owned the vacant lot. Again, really long, complicated story, but
No, it's not that. Wow.
But poor, sloppy work done at the prior closing. But that was something, fortunately, we were able to identify before our buyers got too far into the transaction. It was at the purchase and sales agreement review, looking at the property description. Is this what you're buying? Well, no, that's not what I'm buying.
Okay, and that falls into the category of the title search, right?
Correct. Well, so title search, yes, but the title search springs from looking at the seller's deed, understanding the property, and then going from there.
Okay.
So in this case, we didn't have to do a title search to learn this. The prior example with the drainage easement, didn't know that until we'd done the title search. But the discrepancy in the description, that was evident just by looking at the seller's deed.
You know what? I actually, title search. I'm not sure I understand thoroughly what a title search is. Like what?
No, that's a good question. Very few agents, very few lenders understand that.
Yeah.
Sorry,
I'm sorry, I'm interrupting. Go ahead.
No. So I make the analogy to when you buy a car. So when you buy a car, that the person selling to you has to produce proof of ownership. They have to produce certificate of title issued by the Commonwealth of Massachusetts.
Okay.
That piece of paper proves that this person selling to you owns that car.
Yeah.
But the VIN number and their name on there, et cetera. There is no such document with real estate. So the only document that exists for real estate to suggest the seller owns the property is their deed.
Okay.
So the deed is a transfer document.
Yep.
The deed is a bill of sale.
Mm-hmm.
The deed contains three data points. It has a seller, it has a buyer, it has a description of the property. Mm-hmm. And deeper in the weeds we really need to go here, but the description of the property is not just the address of the property. It is a description of the quarter acre. A piece of land on the east side of Main Street. It's 100 feet this direction, 100 feet that direction, that sort of thing.
Yep.
So that's a deed. But all the deed, again, it's a historic document. So let's say the sellers bought the property 10 years ago.
Yep.
So the deed they're going to present as their proof of ownership is a 10-year-old document.
Okay, 10-year-old document.
And that document simply transferred from whoever signed that deed, transferred to them the property described in that deed.
Okay.
That deed does not tell us what those buyers, now our sellers, what they've done with that property in the intervening 10 years. They could have sold the property to someone else yesterday. It doesn't tell us that the person who signed that deed from 10 years ago even owned the property.
Okay.
So we have to, in order to establish an opinion of title, a title search, we have to research the history of that property.
Okay.
So that 10-year-old deed is our starting point. We have to go back in the records of the Registry of Deeds. All documents affecting ownership of real estate are recorded at the local Registry of Deeds, which is county-based.
Okay.
So we have to go to the records of the Registry of Deeds and look back in time to find where, the seller from 10 years ago, to find a deed where they were the buyer.
Okay.
But then when we find that deed, what do we know about the person that sold to them? We don't know anything about them.
Yeah.
So we have to look behind that deed to find where that seller bought it.
Wow.
On and on and on and on.
Okay.
And so you could, in theory, I assume, you could trace the ownership all the way back to King whoever back in the 1600s, right?
Right. Yeah.
So,
is that possible? Have you ever done
I have not had to do that. But fortunately, under state law, so my liability in searching a title and forming an opinion on the title and certifying to a buyer that I've done my research and you own the property now.
Yep.
Under state law, I have to establish a 50-year chain of ownership. So once we work back in time, we get to 50 plus years, I get to assume that whoever signed that deed from 51 or 60 years ago, I get to assume that they did own it. I don't have to question and challenge, how do I know that they owned it? So the assumption underlying that state law is if there is someone else out there with a claim of ownership, if they haven't shown up in the last 50 years, it's unlikely they're ever going to show up.
That would tend to make sense.
Right? Yeah. There is no statute of limitations So we've run into situations where there are issues from the 1700s that are still title problems.
Okay.
But fortunately, we don't have to go back that far very often.
So as long as we're on, how does title insurance pick up from there? So something that you've always talked about is the importance as a buyer of title insurance. Tell me about that.
So at the end of the day of a title search, I issue a certificate of title to the buyers.
Yep. Okay.
Same words as what you get from the RMV on a car, but dramatically different in significance.
Really? Okay.
Because I'm not guaranteeing anything. It's just an opinion.
Okay. All right.
So it's just I have researched these records and I have not found any reason to think there's a problem with the title.
Okay.
Doesn't mean there's not a problem.
Doesn't mean there's not a problem.
Right.
Okay.
Exactly.
Gotcha.
So I have no idea what happened 60 or 100 years ago.
Okay.
And again, no statute of limitations. The title search that we're doing, we're relying on the record keeping at the Registry of Deeds. We're relying on them indexing everything properly so that I could find everything. Maybe they misindexed something. Maybe I didn't find something.
Okay.
Maybe another title examiner looks at the exact same documents that I looked at and they form a different opinion than my opinion. So at the end of the day, all you're getting from the closing attorney is their opinion the title is good.
Okay.
Now, my opinion is good.
I'm sure it's a pretty good opinion. It's a pretty well-researched opinion.
But I'm human.
Sure.
So then there are situations where people have differing opinions. So title insurance is ultimately the protection. So when you're paying $400,000 for a piece of property, for a house, based on Reynolds saying everything's good, you should be a little nervous about that. So anytime there's a risk, there's an insurance product out there, title insurance.
Okay.
So in every transaction, the lender is always going to require title insurance to cover the loan amount.
I completely understand that. Yeah.
Buyers have the option of buying title insurance to protect their investment in the property, and the vast majority do. I'd say 98+% of buyers do buy the title insurance. It's a one-time premium. You pay it at closing. It covers you as long as you own that property. And if anyone ever raises any issues with the title, then the title insurance company steps up to the plate and will resolve that. And I haven't even gotten in. I didn't even scratch the surface as what sort of title problems you can find. But the list is endless.
Yeah. So there's two different title insurances. There's one for the lender and one for the homeowner.
Correct.
We can learn something new every day. I'm always learning new stuff, right? So. Oh no, that's okay.
Okay. So lenders don't want to take any risk. So they're going to require that the buyer, the homeowner, purchase title insurance to protect the loan amount.
Okay.
They're not going to require that the homeowner buy insurance to protect their investment in the property.
Okay.
So it's optional.
Okay.
And it's always advertised or marked as optional. But again, wise money spent. Usually a few $100s. It's usually not dramatic money.
Okay. So a wise investment, I would say, for a few $100s. Yep. So every time I get the opportunity to interview somebody like Craig, these threads start getting pulled out and all these different really new interesting things come out. And we ended up having a really great dissertation, quite frankly, on title insurance in this particular instance. I think we're at about 30 minutes. I think we should probably start to think about wrapping it up, but maybe we can do this again sometime and
love to
talk about some of the other, because I had this long, as usual, I had this really long list of questions, and we're barely scratched the surface of one part of it. So again, I want to make sure this is Craig Reynolds. So how could they reach out to you, Craig, if they wanted to reach out to you?
Yep. So again, Craig Reynolds, it's Reynolds Law Offices. The primary office here in Lancaster, where we're sitting right now, also have a satellite office up in Fitchburg over on South Street, which is staffed, and another satellite office up in Westford. So we kind of cover the Route 2 corridor, if you will, although we handle closings across the state. I've got clients right now where I've just reviewed a purchase and sales agreement with a woman who's buying down on the Cape. I've got someone buying property up in Andover. I got someone buying property out in Western Mass. So basically anywhere in the state. We don't cross the state borders up into New Hampshire. ReynoldsLaw.com is our website. It's kind of an embarrassing website. We were early to the game with a website back when websites. We were very proud of ourselves back in the day. But we are in the process. We're a month or so from unveiling a brand new website. This is gonna,
Oh, no kidding.
that's going to be the best out there. Yeah, it's going to be all about education. So it's going to be all sorts of informative stuff on there. The things we're talking about here today will be discussed, in our website and whatnot.
Well, geez, I should have led off with that. That's great. That's huge. Well, thank you for taking your time to talk to me today. I really appreciate it.
Absolutely.
And my name's Tom Blake. I'm with REMAX Liberty. I'm a certified residential specialist. And if you're interested in speaking with me, you can reach out to me at 508-951-2803 or Tom at homesjustforyou, all one word, .com, homesjustforyou.com. Thanks. Have a great day. Thanks. That was great.
Good. Okay.